to make you the smartest person in a room about the Second Amendment and the right to keep and bear arms. Sometimes we have to talk about other areas of law. And I'm going to talk about something extremely important to gun owners in America today, and that is the notion of selective prosecution, which is a defense to certain criminal charges. This is a hot topic now. It's something I've been meaning to talk about. And given what's going on in Michigan and in Florida in just the last few days, we have to talk about it, about how Second Amendment supporters, conservatives, and American gun owners can possibly use selective prosecution as a defense against the overreaching Joe Biden Department of Justice. This is an important video, and yes, it touches on the Constitution and the Founding Fathers. When we get back, we're going to touch it all and bring it all together for you in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for an announcement about the next big book very soon. All right, folks, so we have to talk about this doctrine. This is very important. This keeps coming up, as well it should. It's the notion or theory of selective prosecution. Now, selective prosecution, and I'm going to tell you what it means, and I'm going to tell you why it's helpful and important for members of the Second Amendment community to really understand this, because it's the sort of thing that's been going on all across the country, specifically targeting people like you and people like me. Now, selective prosecution is an argument that criminal defendants make in criminal cases that say that a prosecutor, could be a district attorney, could be the U.S. Attorney's Office, they are prosecuting people because of a particular viewpoint they hold and are letting go other people that are similarly situated, and they're drawing this distinction between the two, and they're only prosecuting certain groups of people because of their characteristics, while they're letting other people that are similarly situated doing the same things except with a different viewpoint or a different skin color or whatever it is, and they're letting them go free. Now, this is coming up over and over and over again in American life right now. Just to give you a couple of examples off the top of my head, you can come up with more. For example, let's look at Michigan. You have recently the mother and the father of a teenager who was a student in a high school who shot kids in his high school. And now the mother and the father have been convicted of aiding and abetting, of involuntary manslaughter, different crimes associated with essentially helping the kid or being involved with the kid and not stopping the kid from shooting up the kid's high school. Okay? As far as I know, I'm unaware of any parents of, let's say, gangbangers in any cities that are being indicted and convicted, even though their kids are engaging in criminal behavior with firearms and including murdering people. So here you have one example. In Michigan, the district attorney goes after the parents of this high school shooter, but we're not seeing the same sorts of situations in, let's say, places like the city of Detroit and the like. Okay, that's an example of potentially selective prosecution, where one group of people are being prosecuted, but not the parents of, let's say, gangbangers, number one. Number two is New York City. We know that the former Marine Daniel Penny has been indicted by Alvin Bragg's district attorney's office for stopping a violent homeless person from basically marauding a subway car, right? So he is getting indicted, but then all the illegal aliens in New York City are being coddled. All of the various violent thugs that are in and around the New York City subway station, and we know there are a ton of them. That's why Kathy Hochul, the governor of New York City, has deployed the National Guard to the subway system, because the violence is being, going crazy. And yet, of course, Daniel Penny is indicted, but how many countless people do we read about every day in, let's say, the New York Post, of catch and release by the by the NYPD / the district attorney's office there. But let's go beyond that. Let's make the most obvious example of them all, which is Donald Trump is being indicted for, let's say, holding on to classified documents down there in Mar-a-Lago, even though he was the president of the United States commander-in-chief with the full authority to declassify documents. In contrast, Joe Biden, who had documents from when he was a U.S. senator, no authority to declassify documents, and he had documents after he left office when he was the vice president with no authority to declassify documents, and he maintained those documents in a whole host of places, including in a garage with used cars, right? In contrast, Donald Trump kept his documents in Mar-a-Lago with Secret Service presence. So Again, Donald Trump has been indicted in Florida. Joe Biden is not. Now, when it comes to ATF-related issues, let's not forget the following. Peter Navarro, for example, the Trump administrator, Trump cabinet member, is going to prison now for contempt of Congress. That's where he is right now. 4 months contempt of Congress, going to prison. But then remember Eric Holder? He was held in contempt of Congress by Congress for refusing to turn over documents associated with the ATF's Fast and Furious controversy. So here you have Peter Navarro, a Trump official, going to prison for refusing allegedly to cooperate with Congress. But you have Eric Holder and nothing happens to Eric Holder, even though he is held in contempt of Congress for failing to turn over documents associated with the ATF's Fast and Furious. Again, these are examples of where conservatives are being mistreated by the justice system versus liberals. Now, what can we do about it and what is being said? Well, this is very important. That was a big lead up to understanding what's happening now. There are now judges, federal judges in this country right now are starting to identify this disparity in treatment. And this is very important for you to understand. I'm going to give you the names of these judges. I'm going to link their opinions down below, and I'm going to read some of the quotes that they're identifying, because this trend of the Biden Department of Justice going after conservatives and Trump supporters and gun owners and the like versus allowing allegedly violent thugs and violent gangs to go free because they are liberals, let's say, or they're Democratic voters, let's say, this is not going unnoticed any further. So let's just start with Judge Cormac Carney. Now, you know Judge Carney from California because he is the judge that knocked out most of the quote-unquote sensitive places, which are government-mandated gun-free zone laws in California in the Reno May versus Bonta case, which is now up on appeal to the Ninth Circuit. The Ninth Circuit has still not stayed that order, which means that Judge Carney's decision in favor of the Second Amendment remains the law of the state of California. Now, Judge Carney had a case involving an alleged white supremacist on the one hand, and the white supremacist criminal defendant who was involved allegedly with a riot or some sort of violent activity. The details don't matter for the purposes of this video. And he filed a motion for selective prosecution saying, hey, I went to this sort of rally. It's true. I mean, this is essentially what was alleged. I went to this rally and it's true and allegedly did all the stuff. But look at all the Antifa liberal people that were at the same rally, these kinds of people, and nothing happened to them. And this goes to prove, and this was the argument that the criminal defendant made in front of Judge Carney, this proves that I, given my political viewpoints or my social viewpoints, whatever you want, my First Amendment viewpoints, are being discriminated against, and I'm being selectively prosecuted because the same exact people that were at the exact same events that I was at, that did the exact same bad things that I did allegedly, they're not being prosecuted because they're viewed as liberals. They're viewed as leftist supporting people that support Joe Biden and the anti-Trump movement in America, and they're not being prosecuted by the Department of Justice. And it turns out that Judge Carney agreed with this, and he dismissed the indictment. He threw out the case and ruled in favor of the alleged white supremacist, saying, yeah, this is a clear example of selective prosecution. It's not allowed. Let me give you some of the powerful quotes from Judge Carney, and then we're going to talk about some of the other judges and the other crazy cases that judges have been picking up on in just the last, several months. Judge Cormac Carney wrote the following powerful language about the First Amendment right here. Protecting First Amendment rights, however, is not always easy. People sometimes use their First Amendment rights to spread vitriolic and hateful ideas and beliefs. The struggle of preserving the First Amendment in the face of speech many find dangerous is pronounced during times of uncertainty, division, polarization, and fear. Challenges we unfortunately face today. But the answer cannot be for the government to single out and punish the speech that it and many in the country understandably find repugnant. So, you see what he's setting up. Again, the notion of selective prosecution is the government is treating different people that are similarly situated differently for some wrongful reason. In this case, what Judge Carney is saying, that there's essentially a violation of the Equal Protection Clause. The Equal Protection Clause of the 14th Amendment says that everyone is to be treated equally under the law. And if certain people are being prosecuted and trying to put in jail because of political viewpoints that are different than other people that are doing the exact same criminal acts but have a different point of view, that violates the First Amendment. That is unconstitutional under the Equal Protection Clause, and that is an example of selective prosecution, and those criminal indictments should go away. Judge Carney continues as follows. While defendants openly promoted ideas the court finds reprehensible and likely committed violence for which they deserve to be prosecuted, this case is about something more important. It is about upholding the free speech and assembly rights guaranteed to all of us. It does not matter who you are or what you say. It does not matter whether you are a supporter of All Lives Matter or a supporter of Black Lives Matter. It does not matter whether you are a Zionist professor or part of Students for Palestine or Students for Justice in Palestine. It does not matter whether you're a member of RAM or Antifa. All are the same under the Constitution and all receive its protections. It is those protections that will ensure our democracy endures. We must never abandon any of them. Powerful big point language. These are big ideas. They're clearly the legal concepts. Judge Carney is really getting into this and understanding what's going on here. But he continues, and then he applies the situation to that particular criminal defendant. Here's what he continues on and says. Defendants have established selective prosecution. There is no doubt that the government did not prosecute similarly situated individuals. Antifa and related far-left groups attended the same Trump rallies as defendants with the expressly stated intent of shutting down through violence if necessary protected political speech. At the same time, Trump rallies that formed the basis for defendants' prosecution, members of Antifa and related far-left groups engaged in organized violence to stifle protected speech. And unsurprisingly, in the modern age, they use facilities of interstate commerce to carry out their goals. But then Judge Carney goes on to point out that none of the left-wing agitators were prosecuted. Judge Carney writes the following. The federal government did not prosecute far-left activists who were also responsible for violence at political rallies in the period and places at issue. Indeed, shortly before Charlottesville, the Department of Homeland Security issued a bulletin stating that anarchist extremists' use of violence as a means to oppose racism and white supremacist extremist preparation to counterattack anarchist extremists are the principal drivers of violence at recent white supremacist rallies. To put it simply, RAM and Antifa, which both appear to use violence to silence protected speech, are identical in material respects. The only difference is their speech and beliefs. And again, Judge Carney says this is no-go. He writes the following. No individuals associated with the left who engaged in anti-far right speech and violently suppressed the protected speech of Trump supporters were charged with a federal crime for their part in starting riots at political events. That is textbook viewpoint discrimination. Powerful language from Judge Carney, and absolutely correct. Again, not that anyone subscribes to these sort of white supremacist views that were allegedly the case out there in California. But again, as you can see, the idea is that this Department of Justice is going after anyone associated with Donald Trump and the conservative movement in any respect, and they're simply letting the left-wing agitators go free. That is what Judge Carney found in this opinion dealing with selective prosecution. A link to the opinion will be down below. Judge Carney is not the only judge. We also can turn to the United States District Court Judge Trevor McFadden in the District of Columbia. Judge McFadden, in dealing with some of the January 6th defendants, made the exact same observation about how the Department of Justice under Joe Biden is treating conservative defendants differently than any possible left-wing defendants. We all have seen this with our own eyes, but now the federal judges are starting to pick up on this. This is what Judge McFadden said in a case relating to January 6th. I think the U.S. attorney would have far more credibility if it was even-handed in the concerns about riots and mobs in this city. Powerful language from Judge McFadden. He was drawing a distinction in that case between how the Department of Justice allows marauding mobs with left-wing viewpoints to go free and nothing happens to them, right? And guess what happens if you're any kind of a conservative in the District of Columbia? They throw the book at you. And that's what Judge McFadden pointed out here. But it gets even crazier because there's a crazy case, and this is in some ways the craziest case of them all. It deals with a defacement statute by the District of Columbia. So as you may recall, there's no shortage of basically vandalism and people writing nasty comments on national monuments about the founding fathers. We see people painting over things in protest for climate change, so-called climate change. We see them painting over things associated with, again, the founding fathers, the Confederacy, any kind of, American hero, any of these things. We've seen vandalism all over D.C. and all over the country. But what's quite interesting is that the District of Columbia District Attorney's Office prosecuted some individuals under their district's defacement statute. But guess what those people did? They wrote something, ready for this, folks? Not in paint, not with a magic marker, not with a Sharpie pen. They wrote something in chalk that was going to wash away in the very next rainstorm. But what did they write that got them in trouble? They wrote the following: Black preborn lives matter. Black preborn lives matter. Obviously a reference to you should not kill unborn babies in the context of the abortion debate. That is a political viewpoint that they expressed, and yet they got indicted. Guess what happened? Judge Rao, U.S. Court of Appeals, said this was a no-go and an example of a selective prosecution. This is what she writes. The government may not enforce the laws in a manner that picks winners and losers in public debates. It would undermine the First Amendment's protections for free speech if the government could enact a content-neutral law and then discriminate against disfavored viewpoints under the cover of prosecutorial discretion. The government may not play favorites in the political forum, permitting some messages and prohibiting others. We conclude the foundation, which is the party in the case, has plausibly alleged the District of Columbia's selective enforcement of the defacement ordinance constituted viewpoint discrimination in a public forum in violation of the First Amendment. Wow, powerful language from Judge Rowe. So the critical thing here is that whether it be Judge McFadden or Judge Carney or Judge Rao, people are starting to notice. This is also coming up down there in the Trump case because Judge Eileen Cannon, dealing with the Trump indictment about whether or not he kept documents illegally as the former president, this is going to come up in a big way because she's already indicated some concern that how is it that Donald Trump, the president of the United States, with authority to declassify, is being indicted, but Joe Biden is not, despite Robert Hur's report that Joe Biden had all these confidential classified documents as well, but was never the president. So this selective prosecution argument is going to come up in the Trump context, but I want you to understand this notion of selective prosecution, where similarly situated people who've done equally bad things, let's say, or equally allegedly illegal things, but they only go after conservatives but not liberals. This is a weapon we can potentially use in the context of, let's say, the ATF going after gun owners and Second Amendment supporters, because it's pretty clear that the Biden administration treats you and me and heritage Americans, traditional Americans, whatever you want to call them, people that support the Constitution, whatever you want to call the people that support the American way of life and not the radical new sort of anti-American style that we see out there in many parts of this country, unfortunately. It's pretty clear this administration is trying to treat the Americans differently than the illegal aliens coming into the country and the people that support that and people that would like to undercut the traditional American values, including the U.S. Constitution, which we're all supposed to swear an oath to. And it's pretty clear that this Department of Justice views those groups of people completely differently, and they're prosecuting crimes accordingly. So we need to be aware of this notion of selective prosecution, this defense, so that we can call it out and we can start to use it, because I have a feeling this is going to become more important as we move forward. And now we've got some powerful precedents in just the last 6 months that I flagged here, put links to the cases down below for you to check out and you can use potentially in your jurisdictions, in your hometowns. Of course, we don't want any of you guys to break the law. We don't want any of you going to jail. We want you to do everything right. We need you out there fighting the good fight for the Constitution and the Second Amendment. So we don't want any of you to get in trouble ever. That is never what we want. So there you have it. All right, folks, hope you learned a little bit something here today about the Equal Protection Clause and selective prosecution. Don't forget to follow me on X at 4Boxes Diner. Make sure you subscribe and resubscribe on this channel. We're trying to get to 150,000 subscribers as best we can. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.